of the opposite sex, it is useless to them, as that is not the right that's in question. The Supreme Court has called marriage, quote, the most important decision of your adult life, end quote. So saying that adults can't make that decision who would otherwise qualify but for gender or sex is laughable. Also, the right to marry is deeply rooted within our nation's history, and courts have recognized the ability to marry the person of their choice. That is a quote from the Loving case. And the state has no reason to infringe on that right in respect to these couples. It is not a question of saying, is there a right for deadbeat dads to marry or interracial couples to marry? It is simply saying, does the right to marry extend to deadbeat dads? Does it extend to interracial couples? It is a right that has been recognized, not a new right created. 3, history and tradition have not recognized a man and a woman, or have never recognized a right to marry a person of the same sex. He rebuts this argument and says tradition and history are insufficient reasons to deny fundamental rights to an individual. There are lots of traditions that we've invalidated: slavery, annulled arranged marriages, polygamy, just to name a few. Dowries, covertures, which made women a legal non-entity upon marriage. We've stopped a lot of things and instituted new things which were radical departures from tradition. As Eddie Murphy, as Prince Hakeem said, it is tradition, that tradition must change. Such a progressive thought as he was Princess Zamunda, which Coming to America was his best film alongside Trading Places. Also, he uses Judge Shelby uses the quote from Lawrence regarding due process, which comes from Justice Kennedy, who asshole-ishly voted with the majority in Shelby versus Holder, but I digress. Had those who drew and ratified the Due Process Clause of the Fifth Amendment or the 14th Amendment known that the components of liberty in its manifold possibilities, they might have been more specific. They did not presume to have this insight. They knew times can blind us to certain truths, and later generations can see that laws once thought necessary and proper, in fact, serve only to oppress. As the Constitution endures, persons in every generation can invoke its principles in their own search for greater freedom. He uses this to make a case that it's not the Constitution that has changed, but the knowledge of what it means to be gay or lesbian. The court can't ignore these facts that the plaintiffs are in a committed relationship and want to wed. The court and the state must adopt to this changed understanding, he says. Now getting to the meat of the case, Amendment 3 cannot survive the 14th Amendment because it sections all gay and lesbian UTANs without any rational reason related to governmental interests as stated above. Straight couples will continue to have kids, loving them, and kids will be adopted into families in Utah like they have been, and same-sex couples will continue to do the same with their kids also. Further, on the optimal child rearing argument, this amendment, he says, demeans children growing up in gay or lesbian households, and gay and lesbian children will grow up with the knowledge that Utah believes they aren't as capable of creating a family as their heterosexual friends are. The proceeding with caution argument. This is completely mine here, but I kind of thought to throw it in there. But he actually does mention the Palmore versus Sadati ruling in 1984. Now that was a case in Florida where Mr. Sadati wanted Mrs. Palmore, his ex-wife, to give him custody of their daughter because Mrs. Palmore's current husband is black. Now, the state of Florida did give Mr. Sadati custody, even though Mr. Palmore was a fine example of a father for their daughter. The Supreme Court said, no, this will not happen. Societal stigma is not a reason to deny custody. Florida wanted to proceed with caution, but even they had no evidence that Mr. Palmore was a negative influence on her life. In fact, even if she got made fun of for having a black stepfather, the court doesn't cite this. Well, it does cite this case. I had to slip it in there because the court calls that argument toothless and no evidence to support its claim. Regarding preserving the traditional definition of marriage, page 48 states the following: William versus Illinois in 1970. Neither the antiquity of a practice nor the fact of steadfast legislative and judicial adherence to it through the centuries insulates it from constitutional attack. The argument of we just simply don't know yet, trying to find actual justifications for Amendment 3 was probably more like a cluster screw when cross-examining what exactly the amendment does. Judge Shelby says the following, and as Justice Scalia has noted in dissent of Lawrence versus Texas, quote, preserving the traditional institution of marriage is just a kind of way of describing the state's moral disapproval of same-sex couples. That's on page 48. On that note as well, not all people and churches of Utah morally disapprove of same-sex couples. Judge Shelby notes that by recognizing the right to marry the partner of the same sex, the state allows these groups the freedom to practice their religious beliefs without mandating other groups must adapt similar practices. Page 49. He finally summarizes Utah's case. There isn't one. How are gays and lesbians getting married hurt opposite sex couples? We don't know. But let Amendment 3 stand anyway, because we don't want to know. Somehow out of the sky there will fall a reason. And you just have to sit there and say Utah legislature can propose a rational reason to uphold Amendment 3. Judge Shelby would have none of that. Amendment 3, Judge Shelby says, discriminates based on sexual orientation and fails even rational basis review. The court finds that Utah's prohibition on same-sex marriage violates the plaintiff's right to equal protection under the law. And on page 52, he says this: moreover, the Constitution protects the plaintiff's fundamental rights, which includes the right to marry and the right to have that marriage recognized by their government. These rights would be meaningless if the Constitution did not prevent the government from interfering with the intensely personal choices an individual makes when that person decides to make a solemn commitment to another human being. The Constitution therefore protects the choice of one's partner for all citizens, regardless of their sexual identity. Therefore, the court ordered the state to enjoin or stop enforcement of Utah Amendment 3, as well as the statute's barred recognition of same-sex couples. Couples went out and got legally married in Utah. We don't know how long that will be, because the 10th Circuit would have to put a stay on the ruling pending appeal or pending pending all of that. However, for now, if you have been waiting a long time and want to get married, I suggest you go and get that license. I'm sure that a lot of pictures are being posted on Facebook, and a lot of people are going through Kleenex as the day that many couples have waited for finally hits Utah. So it's number 18, and also as this becomes the first constitutional amendment to actually be ruled unconstitutional on its merits. That is pretty big, because even the Supreme Court was not able to reach the merits because of lack of standing. But there is a poetic justice to this. The state that funneled all that money into Proposition 8 to get it passed, and passed in that state, and put all that money into the defense of Prop 8 in court, and they lost at home. The appeals process will most likely be followed, as Governor Herbert slammed the ruling, saying, "I am very disappointed an activist federal judge is attempting to override the will of the people of Utah. I am working with my legal counsel and the acting attorney general to determine the best course to defend traditional marriage within the borders of Utah." Of course, they didn't say anything like that when Nevada and Hawaii's marriage bans were upheld. Neither Indiana, Wisconsin, and many other states or any other states. Of course, this is only an activist judge when you don't like the ruling. So some parting words from Peggy Tomsick, the attorney who represented the three couples, applauded Shelby's courage in making the ruling. "We cannot capture in words the gratitude and joy the plaintiffs feel," Tomsick said in a statement. But she warned that the legal fight was not over. During this month's hearing, Tomsick contended marriage is a fundamental right protected by the U.S. Constitution. She said the case embodies the civil rights movement of our time, saying discrimination has gone on long enough. She said of Utah's law, which passed with 2/3 of the vote, is based on prejudice and bias that is religiously grounded in the state. Hence why I was so surprised. But at least I'm pleasantly surprised for now anyway. All right, YouTube, thanks for letting me talk to you. See you later.